Can I adjust status under employment-based category? I overstay my visa. Can I adjust status because I have withholding of removal? Can I still adjust status under employment-based category? In this video, we are going to answer those two questions. My name is Bijoux Ngwanda. I'm an immigration lawyer based here in DC. I do work with individuals across the country and around the world because we are dealing with complex U.S. immigration laws cases. If you're into my channel, again, please go ahead and subscribe. If you're not new, welcome back. Thank you for subscribing. And please do not forget to hit the notification bell so you don't miss out on anything. And please do not forget to join us in celebration of all mothers, okay? Mother's Day celebration. We're gonna celebrate here on YouTube Friday, okay? Oh no, it's not Friday. It's gonna be Saturday. Sorry, this Saturday, May 13, 3 p.m. Eastern time. Bring all your questions, okay? The theme is 7 ways your U.S. citizen child can help you get protection or lawful status. So don't forget, bring all your questions. We'll try our best to celebrate Mother's Day together on Saturday again, 3 p.m. Eastern time here on YouTube. Yes, let's get right into it. Can I adjust status under employment-based category? Okay. The first question is, do you have an approved petition? In that instance, it's going to be a I-140 petition. Do you have it? Was it approved? If the answer is yes, then we start looking into admissibility issues or inadmissibility issues, okay? So if you're admissible or if you have any inadmissibility issues, in this case, when somebody already says that I overstay my visa, it means they have a unlawful presence, okay? Failure to maintain continuous lawful presence. So how can you cure that? 3 exceptions, okay? The first one is, do you qualify under 245I? What is that? It simply means that if you have on top of your I-140 petition that has been approved, if you have another petition that was approved on or before April 30th, 2001, or a petition was approvable at the time it was filed with that cutoff date, it could be employment-based, labor certification, or family-based. Then you can use it to cure your unlawful presence. At that point, we're going to say, yes, you can adjust status. Remember that 245I helps with unlawful presence, entry without inspection, working without authorization. So it pretty much covers most of the common inadmissibility issues. That's number 1, okay? Number 2, if you don't have 245I, then we go to the second exception. Can you apply for a waiver? I-601A, unlawful presence waiver. Can you apply for it? How do you qualify for it? Well, you have to have basically a parent or a spouse who's a U.S. citizen or lawful permanent resident, and then be able to apply for it. Once you get approved, then you can go outside of the U.S. at the consulate. At that point, it's no longer adjustment of status. It becomes consular processing, okay? You go get your visa from outside. But remember, there is a lot of risk involved with it, because if the I-601 only claim unlawful presence, only forgives that if it's approved, of course. But if you have been working without authorization, if you have been doing a lot of things that renders you inadmissible, well, I-601A, it's just not going to work for you, because you might get it approved and then go outside and be stuck there because now they find some other stuff that are causing you to be inadmissible. So then we move on to the exception number 3. Number 3 is for technical reason. If you overstay your visa, but still you qualify under technical reasons, you can still adjust status. How does this one is gonna play out? How? Okay, the way this one works is this. You get here, for example, with a B1/B2 visa, then you apply for, let's say, for a asylum within 6 months. Okay, within 6 months of the validity of your visa, and the asylum is still pending, so USCIS hasn't decided yet, and now you have an I-140 approved, so you're gonna claim that exception. But remember, that's debatable. Okay, works better in the Ninth Circuit Court because they have case law to support that argument. In some circuits, that become persuasive. You really have to convince them to go with that exception. Okay, so now we're moving on to the second topic. I have withholding of removal. Can I adjust status under employment based? Still the same thing, but the difference with withholding of removal is this. First, once you get I-140 approved, then you have to go back to court to ask them to reopen the case and terminate removal proceedings. But you have to convince them why they should do that. Then you have to show them your 245I exception and say, well, you can do it because I have 245I exception. It's going to help me adjust status in the US. If you have to go through consular processing, that again, you have to get I-601A approved, meaning that you have either a spouse or a parent, lawful permanent resident, or you're a citizen. I-601A get approved, you go back to court, remember, withholding of removal. Ask them to dismiss the case so that you can pretty much travel outside to get your immigrant visa from outside. But remember, because sometimes the reason that you were actually you ended up with withholding of removal is because asylum was not granted. Now, if you go home, you're not going to be able to go home. You can go to a different country, because the moment you start going home, you make the first case of asylum frivolous, and that's going to complicate your situation. Then we go back to the third exception, but this one, it's really not going to work, because by the time you end up in removal proceedings, you should have claimed that. And now that you already have withholding of removal, claiming technical reasons in this instance is really, I believe it's not going to work. Okay? Based on the fact that you have already been order removed, so you technically here just to wait until sometimes they might execute that order of removal, because remember, withholding of removal is technically you being in removal. I mean, the person who has that. It simply means that you're still in removal, you have been ordered removed, but DHS or the judge has ordered DHS to withhold that, okay? To pretty much not execute that order of removal. That's why people can't go outside. That's why they only have work permits. So with withholding of removal, only two things that might work for you in case of adjusting under employment-based category. One is 245I if you have it. The second one will be going through consular processing, but that's a long shot too. So it's very complicated. That's why we spend 1 hour trying to explain this one, But still, I guess the client did not really understand the reason why he cannot adjust status. But the moral of the story, or the conclusion in all that, is this, right? If you have overstayed a visa, you can adjust status on the employment base if you have 245I. Trust me, we've done it before and it worked. If you don't have 245I, it's a long shot because you have to get I-601A approved first. Then get outside of the country to do consular processing. And a lot of risks involved. You can try for technical reason, and that too is debatable. It's not a sure thing, but you can debate it depending on what circuit court you find yourself in. And when you have withholding of removal, that's another different story. First of all, you get I-140 approved, you have 245I, then you go back to court, try to ask them to basically join the motion with ICE, right? You open the case, terminate removal proceedings, or ask ICE to dismiss the case so that you can pretty much try to adjust status with 245I. So that was it for today. I hope this one was clear, right? I really hope this one was clear. If still gets complicated, please comment below. And also, we will have a live session on Saturday. I might even have another live session before Saturday, but the one that we know for sure is going to be on Saturday in celebration of Mother's Day. We are going to have a live session, 3 p.m. Eastern Time, 7 ways your U.S. child can help you get protection or lawful status. And really, we're really going to help you answer those questions. You can ask your questions. We're going to have an 1 hour full to actually answer your questions for you. Okay? I guess we have a lot of immigration news going on. I might just go live at some point to just go with this immigration news and talk about what's really going on with those Biden policies, and why not. So if you need a consultation with me, again, you can schedule it on your own time, of course, by using the consultation link in the description box below. Until next time, bye-bye.